All right, welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call this morning's docket. When I call your name, please say present or here and raise your hand so I can acknowledge you for the docket. Christina Beaver. Giovanni Chavez Rosales. Danny Dittman. Danny Mike Dittman. Christian Grindel. Starsky Robinson. Starsky or Starsky Chris Robinson. Shaquille Rogers. Joseph Rushing. For the record, Wayne Dell Whitworth, CR 22162, set for arraignment today on unlawful possession of firearm by a felon. Court has received and confirmed documentation from the Reunion Plaza Healthcare that Mr. Whitworth is receiving 24-hour care after a minor, or no, I'm sorry, not a minor, after a motor vehicle collision. So the court has documentation of that. We have to give that to the state. Chase Enox. Here. Carlos Padron. Carlos David Patron. Jeremy Hendricks.
Pleasure, Counsel.
Thank you, Mr. Calabrese. Holly Mormon.
Your Honor, she is not present. It's my understanding, speaking to our Smith County Attorney, that she is in quarantine in Smith County Jail.
That's what I've received as well. So we'll recall her in just a moment. Get her reset. Thank you. Thank you, Mr. Warren. Mitchell Gilbert. Mitchell Centel Gilbert. Jennifer Gonzalez.
Judge, just sort of recall, she was on her way from Longview, and when I talked to her, she was over in the Tyler area.
All right, thank you, Mr. Man. Haley Pettis. Stephanie Rios. Stephanie Rios. Crystal Williams. Crystal Antoinette Williams. Wendy Wolf. Guadalupe Bahina. Thank you, Mr. Jarvis. Andrea Young. Robert Gerard. Robert. Thank you, Mr. Schmidt. Julie McClellan. Julie Darlene McClellan.
And she must have been picked up by the bench.
Can y'all look into that for me? Let me. Dylan Osterreich. Dustin Hall. Thank you, Mr. Weiner. Gregory Beaver. Leland Cashin. Omar Galan. Billy Jennings. Chester Perry. Robert Schultz. Robert Michael Schultz. Danny Smith. Seth Atkins. Santana Martinez. Brian Mason. Zachary Wooten. Charles Massey, for the record, waiver of arraignment, e-filed, approved. Pre-trial has been set August 23rd. All right, counsel, if we have anyone that's ready. Jarvis. Guadalupe Bahina, CR 21160. Ms. Bahina, if you'll come up to this podium right over here, we kind of changed things up a little bit. Yes, thank you, Mr. Jarvis. And for the record, it's my understanding that Mr. Knoll has contracted COVID. He's contacted the court, and I don't believe that he had planned on appearing via Zoom. I think he was having connectivity issues. Any objection that we go, I see that this is set for plea today.
Yeah.
Any objection that we go forward with that?
We both signed.
Okay, thank you, Mr. Jarvis. All right, Mr. Jarvis, can you help your client? Will you just lower that laptop to where I can see her? I know that's probably there. Well, no, I mean, there we go. There we go. That's all right. And Ms. Bahina, you can also step to the side if you want to, so you can see me. I know that's not made for certain size people. All right, thank you, Ms. Bahina.
And where do you want us, Judge? Just here?
Oh, yeah, you're fine. You're fine right there. Yeah, there at council table. All right, this is CR 21160, State of Texas versus Guadalupe Bahina. Ms. Bahina, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you may place your hand down. All right, Ms. Bahina, are you a United States citizen?
Yes.
And have you ever been diagnosed with any type of mental condition?
No.
Have you ever been diagnosed with any type of mental condition, anxiety, depression,
Yes.
bipolar, schizophrenia, anything of that nature?
I have anxiety.
Anxiety? Are you currently on medication or undergoing treatment for anxiety?
No.
No? Okay. And you do read, write, and speak English, is that right?
Yeah, I speak to.
So you're bilingual?
Yeah, I'm bilingual.
Is English your first or second language?
English my second.
Your second? Okay. Do you believe that there's been any difficulty communicating in the English language about your case and the legality and all the things that you discussed with your attorney? Do you understand all of those things?
Yes.
Okay. All right, and Ms. Bahina, in this case, you are represented by Mr. Kurt Knoll, and you are also represented by Mr. Jarvis. And Mr. Jarvis is here with you today. You've understood the court to inform you that Mr. Knoll is ill and unable to be in court today. Is that correct? And do you want to go forward with this plea without Mr. Knoll being here?
Yes.
Okay. All right. And are you pleased with Mr. Knoll and Mr. Jarvis's representation of you? Are you pleased with them being your attorney, and do you understand everything that's going on in this case? Have they helped you in this case?
Yes.
Okay. Is there anything about this paperwork that you've read and signed today and discussed with your attorneys that you do not understand?
I do understand.
You do understand? All right, Mr. Jarvis, have you and Mr. Knoll explained the documents and Ms. Bahina's rights to her?
Yeah, we went through it.
All right, and do you believe that she understands everything that has been explained to her and all of the rights that she's waived today? She understands that what she's doing, and do you believe that she's done so intentionally, knowingly, and voluntarily?
I believe, yeah, they're not her last against the number.
Okay, thank you, Mr. Jarvis. All right, Ms. Bahina, in this case, you are charged with a state jail felony offense of criminal negligent homicide. A state jail felony in the state of Texas carries a range of punishment of not less than 6 months in confinement in the state jail prison or more than 2 years. If you are convicted of this offense and sentenced to prison by either the court or a jury, that would be the range of punishment, minimum 6 months to a maximum 2 years. Do you understand that?
Yes.
I see in this case that there's a plea agreement that's being proposed to the court, and that is that you would plead guilty to that crime. And the state would be recommending to the court that, well, actually, was she charged with manslaughter? Okay. The plea agreement in this case is if you plead guilty to the lesser included offense of criminal negligent homicide, that the state would ask the court to defer a finding of guilt in your case, place you on community supervision, or also known as probation, for a period of 5 years. You would also have to pay $1,000 fine plus court costs of $290 plus reimbursement fees of $90. In addition, you would have to serve 60 days confinement in the county jail as a condition of your probation. Is that the plea agreement as you understand it?
Yes.
That's what you're asking the court to approve today? And have I stated the plea agreement correctly, Mr. Jarvis? Okay. All right, Ms. Bahina, understanding the plea agreement, understanding what the range of punishment is, do you still wish to go forward with the plea?
Yes.
All right, Ms. Bahina, how do you plead to the lesser included offense of criminal negligent homicide? Guilty, not guilty?
Guilty.
Are you pleading guilty, Ms. Bahina, because you are guilty of committing that crime?
Yeah.
Has anyone threatened, forced, or pressured you to plead guilty to this crime?
No.
All right, court will accept the defendant's plea of guilt. Mr. Jarvis, any objection to the state's evidence as offered?
Okay.
All right, there being no objection, state's evidence is admitted and court does take judicial notice of Ms. Bahina's judicial confession. Anything further from the state?
Your Honor, just, I know the court's going to review the discovery there. This is the type of case, Judge, where we don't often make this type of plea agreement, as I'm sure the court is well aware. In this particular case, however, the victim was Ms. Bahina's own 5-year-old child. And given that, given what she has emotionally been through, and given the nature of the negligence here, which was not driving, was not substance, we felt like this agreement was appropriate in this particular case.
Thank you, Mr. Curry. Anything further from the defense, Mr. Jarvis?
To do it on the 60 days, and she worked it out of probation, and she was.
Yes, I see that the plea agreement says days to be determined with the probation department.
No, I know there's.
All right, court's going to review the evidence. All right, the court has reviewed the evidence. The court does find that there is sufficient evidence to convict Ms. Mahina of this offense. The court will follow the plea agreement in this case. Court hereby defers a finding of guilt on the lesser included charge of criminal negligent homicide. Court assesses punishment at 5 years deferred community supervision. Orders her to pay a $1,000 fine, $290 court costs, $90 reimbursement fees. Court will order Ms. Mahina to serve 60 days confinement in the county jail as a condition of her community supervision, with those days to be determined by the Van Zandt County Community Supervision and Corrections Department. Ms. Mahina, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm very sorry for your loss. All right, I'm gonna have you come forward to be fingerprinted by the deputy, and you can speak with the probation officers, okay? And Mr. Jarvis, you're welcome to go with her.
Thank you.
Mr. Schmidt, are you ready? Right. Dylan Osterreich, CR 20223. All right, Mr. Osterreich is set for pretrial today, Mr. Schmidt.
That's correct, Judge. I've spoken with Ms. Curry last week. As far as we're here for discovery status as well. I think that there's some outstanding discovery still. However, I think we're making movement towards resolution, but at this point, we'll move it to a docket call. In the event, I'd ask leave the court to file pretrial later on down the road if it becomes necessary, but at this point, I don't think it is.
Okay, thank you, Mr. Schmidt. All right, the court will grant you that leave as requested. The court will set Mr. Osterreich for docket call. Mr. Schmidt, are you available on either August 9th or 11th?
I think I have the 9th available, Judge, yes.
All right, court will set Mr. Osterreich for docket call August 9th at 9 a.m. Once you get the yellow copy, you're free to go. All right, Mr. Hendricks is set on a motion to revoke. Mr. Clavery, any announcements?
Yes, Your Honor, the request is to be put on your contested docket. Our expectation is that we'll be able to work out a reasonable agreement with the state on the advanced state date. Or the court would prefer another docket call. I just recently been retained. I'd like to have an opportunity to review the motion to revoke and to discuss that further with Ms. Curry.
Okay, what we'll do then is I will set you out to the August contested, so that'll give you about 60 days. That's fine. Okay, so we'll set this for August 25th. That'll be at 9 a.m. Mr. Hendricks, once you sign and get the yellow copy, you're free to go. Okay, thank you. As long as you can sign and date it, after that, you just give us the white copy, give him the yellow copy. Good to go.
I believe it's all this, I have this morning, big states.
Yes, sir. Good to see you. Thank you. Mr. White, who are you ready on?
Could we call up Mr. Mason?
Brian Mason, CR 2270. Mr. Mason set for pretrial.
Yes, Your Honor. I have a email with the state. I've got an issue, I think, with the, well, I've got an issue. I don't know if they have the issue this time. But, anyway, I'm gonna ask for it over Fred and Jerry.
Okay, so motion to suppress has already been filed.
I have not filed it yet, Your Honor, but I will.
I could set this either on July 26th, that's 3 weeks. Or we can do August 25th.
Let's do August 25th, Your Honor. I got 2 other cases set on that docket.
Any objections from state?
Oh, Your Honor.
Okay. All right, court, we'll set this for evidentiary hearing on August 25th. If you end up not filing a motion to suppress Mr. White, then that day will become docket call.
That's fine, Your Honor. I will give it 5 day roll.
All right, Mr. Mason, once you sign and get the yellow copy, you're free to go.
Your Honor, can we call Mr. Wooten?
Zachary Wooten, CR 2255 and 56. Mr. Wooten set for pretrial.
That's correct, Your Honor. We don't have any additional pretrial filing at this point. By court standard motion, as the call.
All right, court will set Mr. Wooten for docket call. Are you available on August 9th or 11th?
I'm available on August 9th, Your Honor.
All right, court sets Mr. Wooten for that date at 9 a.m.
Mr. Wooten, free to go. Your Honor.
Yes, free to go.
Thank you. Miss Martini.
Santana Martinez, CR 2232. All right, Ms. Martinez set for pretrial as well.
Yes, sir. We don't have any additional filings on this. We'll abide by the court standard discovery motion. Ask for it moved over to docket call.
All right, court will set Ms. Martinez for docket call on August 9th, 9 a.m.
Your Honor, Mr. Atkins.
Seth Atkins, CR 22-1.
Your Honor, Mr. Atkins, there's another case on this, there's an aggravated assault, email with the state. My understanding is that Ms. Curry was attempting to get the case filed from the sheriff's department. It's going to be extremely some of this. I would ask for it, but I know the state's doing what we can to get it.
All right, the court will set Mr. Atkins in for another docket call on August 9th. That'll be at 9 a.m.
All right, that's all I have.
Mr. White, Mr. Atkins, I've got a couple of concerns with him. My docket indicates that he's failed to report on pretrial for both May and June.
Your Honor, he been incarcerated prior to that.
He was incarcerated in May and June.
Maybe half of it, Your Honor. Mr. Waddell contacted our office, we made Mr. Atkins aware that. I think we got that read to back, Your Honor.
I'm gonna go ahead and UA Mr. Atkins today because I wasn't able to UA in June. So Mr. Atkins, go ahead and have a seat over here. And Mr. Waddell will be with you shortly. Oh, there he is right there. Just go ahead and go with him. Mr. Waddell, are you ready?
Yes, Your Honor, Dustin Hall.
Plea. Dustin Lee Hall, CR 21-385. Sir. All right, Mr. Hall, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you may put your hand down. Your name is Dustin Lee Hall, is that correct?
Yes, sir.
And Mr. Hall, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, sir.
In this case, you are represented by your attorney, Mr. Justin Weiner. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
No, sir.
Mr. Weiner, do you believe your client to be competent today?
I do, Judge.
And you've explained to him his legal and constitutional rights?
Yes, Your Honor.
You believe that he understands those and the rights that he's waiving today, he's doing so intentionally, knowingly, and voluntarily?
Yes, Your Honor.
All right, Mr. Hall, I see here that you've been charged with a second-degree felony offense of possession of a controlled substance of penalty group 1 greater than or equal to 4 grams but less than 200 grams. That is a second-degree felony offense, which does carry a range of punishment if convicted and sentenced to a minimum of 2 years to a maximum of 20 years confinement in prison and an optional fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, Your Honor.
I see here that the plea agreement in this case is that you would plead guilty to this crime in exchange for the state's recommendation that the court defer a finding of guilt place you on community supervision for 5 years, have you pay a fine, restitution, court costs and reimbursement fees, and the state would be asking the court to dismiss another case, which is also possession of controlled substance case. Is that your understanding of the plea agreement?
Yes, Your Honor.
You understand if the court approves this today and I place you on deferred community supervision, if you go on that deferred community supervision and you violate any of the terms and conditions of that community supervision, the state could file a motion to adjudicate your guilt, which means they could file a motion to bring you back before the court to allow them to put on evidence. And if the court finds that you violated the terms and conditions of your community supervision, the court could convict you of this offense. And the court would be able at that time also, if it sought to do so, to sentence you anywhere between that minimum all the way up to the maximum in prison. You understand that? All right, understanding the plea agreement, understanding the range of punishment, do you still wish to go forward with the plea?
Yes, Your Honor.
All right, then, Mr. Hall, at this time, I would ask you, how do you plead to the second degree felony offense of possession of a controlled substance, penalty group 1, greater than or equal to 4 grams, less than 200 grams?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
And now you pause and you ask Mr. Weiner.
Well, I always think it's interesting because technically we have been promised something in return, which is the probation or a plea of guilt. So, but nobody's said, you know, you have to do
Right.
this or
Right now.
given you anything you plea, right?
No, sir.
Did I say promise? Did I say that threatened, forced, or promise? I thought I said threatened, forced, or pressure. If I said promise, I meant pressure.
I always make that joke on our plea paper with my clients. Like, it's kind of funny that you actually are receiving something in return for the
Sure.
probation. So I
Sure.
apologize.
Right, well, we know it's a plea agreement, and if I misspoke, then I apologize. Has anyone threatened you, forced you, or pressured you
No, sir.
to enter into this plea agreement today?
No, Your Honor.
You're doing this because this is what you want to do
Yes, sir.
under the circumstances. I'm sure this is not what you want to do if you had your choice of matters, but in this arrangement that you have with the state, you're seeking and you're intentionally doing this.
Yes, sir.
Okay, all right. All right, court will accept Mr. Hall's plea of guilt at this time. Mr. Weiner, any objection to state's evidence?
We have no objection, Your Honor.
All right, state's evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state,
No, Your Honor, we would rest close at this time.
from the defense?
Rest in post, Judge.
All right, take just a moment, to review the evidence. Is there a lab report with this discovery?
I don't believe it's part of states 1, but we have received a lab confirmation. Judge.
There is a lab report, Judge. I can print it off for me. Print that and show it to Mr. Weiner to make sure it's.
Oh, I don't have any objection. I previously received here. Yes. Judge, state of Auburn State's Exhibit 2, which is why I'm reporting.
Any objection, Mr. Wine?
We have no objection.
All right, State's Exhibit 2 is admitted. All right, court has reviewed the evidence and the court finds that there is sufficient evidence to convict Mr. Hall of this offense. Court will follow the plea agreement in this case. Court hereby defers the finding of guilt on the second-degree felony offense of possession of a controlled substance in penalty group 1. Court will defer finding of guilt at this time, place Mr. Hall on 5 years community supervision, order him to pay a $1,500 fine, $180 restitution, $290 court cost, $35 reimbursement fees. The court will dismiss under section 1245 of the Texas Penal Code, DA 2021-121, possession of controlled substance between 1 gram to 4 grams. Mr. Hall, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. Have you step forward here with Deputy Phillips to be fingerprinted. After that, you'll report to Ms. Burns here for probation.
Thank you, Judge.
Thank you, Mr. Warren.
That's all I have. Have you excused?
Let's reset this morning.
Oh, that'd be
You ready to
great.
do that, Mr. Head?
Yes.
You're clear right there, Mr. Warren. For the record, CR 16139, State of Texas versus Holly Elise Mormon. Ms. Mormon was set on a motion to revoke, a motion to adjudicate. It's the court's understanding through Mr. Weiner that, and the court has confirmed this, that Ms. Mormon is currently incarcerated in the Smith County Jail. Do you have any information for the court, Mr. Weiner, about how long she may be there on the related charges she has there?
I spoke to Mr. Jarvis this morning. He is her court appointed lawyer in Smith County. It's my understanding it's the quarantine process. I don't know when her quarantine started. I just found out this morning.
Are her charges similar to what we have here?
It's a motion to proceed or a motion to revoke rather on probation as well, Judge.
All right, then are you familiar with Mr. Head's schedule, or do you want to schedule it with your cases?
I'll just pretend I'm Mr. Head for the purposes of this. That's okay.
I don't know if it's okay with him, but it's okay with me.
Okay.
All right, let's look at just setting it on the contested docket on August 25th. That'd be in the morning.
No, that'll be great, Judge. I'm potentially in a jury trial, but you know how that is right now. So is that at 9 a.m.?
That would be at 9 a.m. yes.
Okay, great. So the August 25th at 9 a.m. Yes, sir.
And just let Mr. Head know that is the contested docket.
All right, I'll give away the podium and get this filled out.
All right, thank you, Mr. White. Mr. White, you ready?
And one other great thing, Judge.
Yes.
I had settings in Rust.
Who do you want first, Mr. White?
Your order is fine, Judge.
Okay. We'll start at the top. Gregory Beaver, CR 2287. Mr. Beaver set for pretrial today.
That's correct, Your Honor. I filed 3 motions, and that's no opposition to any of them. I don't see there being any other pre-trial motions at this time. However, I did file one to file additional motions.
Okay. All right. Court will set Mr. Beaver then for docket call. Mr. White, are you available on August 9th or 11th?
9th sounds good.
Court sets Mr. Beaver for docket call August 9th. That will be at 9 a.m. Mr. Beaver, once you sign and get the yellow copy, you're free to go. One. That's seen before you go. Yes, I'm sorry, Mr. Watts.
No problem. I need to get some of these signed.
No problem.
Leland Cashin, CR 2149.
Got this pre-trial, there's no additional vote. Still.
All right, so we'll move that Mr. Cashin then for docket call on August 9th. Once he signs, it gets the other copies for you. Omar Galan, CR 2220. Galan's also set for pre-trial.
Yes, Your Honor, same announcement that we had on the prior two cases. The only difference is right now, I know I filled out his sheet, but I'm not buying it right now. But we would be needing to set this for a done fall.
All right, there being no contested pretrial motions, court sets Mr. Galan for docket call on August 9th at 9 a.m. Once you sign that form and get the yellow copy, you're free to go. Billy Jennings, CR 2227. All right, Mr. Jennings also set for pretrial.
You know.
Same song, same verse. Same song, same verse. All right, there being no contested pretrial motions, court sets Mr. Jennings for docket call August 9th at 9 a.m. Mr. Jennings, once you get the yellow copy, you're free to go. Sign right here. Right here. We fill out the ones that chase the dots. But we're trying to chase the dots. Okay. She's out today. It's gonna be CR 21324.
Yes, sir.
They're on page 2. Chester Perry.
Your Honor, this pre-trial, we've already filed a pre-trial motion for benefit, requesting another pre-trial on this on the basis of. We think there may be a body cam possibly out there that we don't have. And the state had no opposition to us ask for a pre-trial, just to double check and see if there were.
This Mr. Smith.
And state, does the state investigated that or believes that there may be a body cam that has?
Your Honor, Mr. White tried to come talk to me about it last week. I was out sick, so this isn't something I had the opportunity to look into yet. But we will get it looked into and settled one way or the other.
All right, court will set an additional pretrial for Mr. Perry, August 9th at 9 AM. Once you get the yellow copy, you're free to go, sir. Are you ready on Danny Smith?
Yes.
Danny Smith, CR 22-118. All right, Mr. Smith is set for pretrial.
That's correct, Your Honor, but we are requesting another pre-trial in this case, basis being there's some discovery that didn't get on the court.
Any objection from the state?
Mr. White brought that to my attention this morning. We've relayed all the discovery we have, but we would be unopposed to his request for additional pretrial.
All right, court will reset Mr. Smith for an additional pretrial on August 9th. That'll be at 9 AM.
For the court's records, I have made that available to Mr. White already.
So thank you, Mr. Woodley.
We did this morning. We're unaware.
All right, Mr. Smith, I need you to report to my pretrial release officers. We're gonna have conditions of pretrial release on your case. That means the bail that you posted in this case is gonna have conditions. All right, some of those conditions are going to include that you don't drink alcohol, you don't do drugs, don't commit new offenses. So
It'd be allowed.
I work for Ace Tire and Axle, and I mean, I take more random drug tests than you can imagine as a CDL driver.
good, okay. And I know they're a good organization. So I'm gonna have conditions of pretrial release. So come over here, you'll fill out some additional paperwork, and then once you're done with them, you're free to go.
Yeah, I'll probably be gone until I come back for work.
Okay.
I'm gonna enter the meeting on the same thing.
Yeah, just let them know. They'll work with you. All right, so the court's going to call Robert Schultz, CR 21-310, CR 22-116. Mr. White, it has been made known to the court through Mr. Schultz bondsman that Mr. Schultz was involved in a motor vehicle accident and has been in and out of the hospital. So what I'll do is today is Tuesday, July 5th. Court will have his name called loudly, distinctly at the end of the docket today. If he doesn't appear, then the court will enter judgment nisi in this case. However, the court will take that under advisement until noon on Friday to give
This right?
noon, yes, on this Friday, to give you and Mr. Nicholas an opportunity to provide the court with some documentation to support that.
Well, hopefully. The bail bondsman has an accurate phone number. I haven't had one that works since December.
Well, you may want to check with my coordinator because he had some civil litigation that I believe we have email, probably a couple of contacts for him. So you may want to meet with her. She may have some additional information for you.
Okay.
So I'll take that. I'll have his name called. If he does appear, then I'll contact you and I'll give
You
you.
want me to reset? Sorry.
No, not at this time. If he shows up, then I'll let you know. We'll do one, but if not, then we'll do the nice eye and I'll have it under advisement for Friday.
That sounds good. I believe that takes care of everything I've got, John, baby.
Yes, thank you, Mr. White. Mr. Manning, you ready?
On top of that,
Who are you ready on?
if we can reset Ms. Chester's client, Mr.
Oh, yes, Mr. Enox. I'm glad you brought that up. That was my intent.
Judge, I don't have a case number on that. If I can.
And I, I'm sorry, Deputy Phillips, you filled that out.
Oh, cool.
All right, this is cause number, Mr. Enox, come on up, sir. This is cause number CR 21324, State versus Chase Ray Enox. Mr. Enox was set to enter a plea with the court today with counsel, Ms. Casey Chester. It's my understanding that Ms. Chester may be giving birth today. So what we'll do is, I understand, Mr. Manning, that you were attempting to stand in to complete the plea on behalf of Mr. Enox and Ms. Chester. It's my understanding that we need to reset the case. Is that correct?
Yes, Judge. I spoke to the court coordinator. She made me aware of the situation. I spoke to the state based on my conversation with the state. We felt like it would be best, given the work that Ms. Chester's put in this case and the type of issue that's being handled, that we should reset. I discussed that with Mr. Enox, and he confirmed that he would be more comfortable doing that. And so we request a reset for a plea. I believe, and I don't know, Ms. Abraham had mentioned 3 to 4 weeks would be before Ms. Chester is available. So I don't know what the court has on its calendar in that time frame.
Let's we'll set it August 23rd. Any objection to that? If not, we'll do August 23rd, give her some time to get back on her feet. We'll set that at 9 AM.
So,
All right, you're free to go. Yes, sir. All right, Mr. Manning.
Judge, ready, Ms. Pettis?
Kaylee Pettis, CR 2274. Ms. Pettis is set for pretrial.
Yes, Judge. Ms. Pettis, I have received the discovery on her case. I discussed it with her this morning. She's set up an appointment to come and visit me in my office to review the discovery for July 12th. And so we request to reset after that date.
Any objection from the state? All right, court, are you available on August 9th or 11th?
Judge, August 11th would be great.
All right, court sets Ms. Pettis for an additional pretrial on August 11th at 9 AM. Once you get the yellow copy, you're free to go, Ms. Pettis.
Ready on Miss Wendy Wolf.
Wendy Wolf, CR 2253. You may.
Stipulation of offense was one thing.
Are we ready? All right, are you Wendy Camille Wolf?
Yes, sir.
All right, Ms. Wolf, if you'll raise your right hand, I'll place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth? So help you God. All right, let me place your hand down. Ms. Wolf, are you a United States citizen? Do you read, write, speak English? Have you ever, speak up so my court reporter can hear you. She's got to take down what you say, okay? Do you read, write, and speak English?
Yes.
All right. And have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with his representation of you?
Absolutely.
Do you feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read and signed today that you do not understand? Okay. All right. And Mr. Manning, do you believe your client to be competent today?
She is, Judge.
And you've explained to her her legal rights?
I have.
You believe that she understands those and the waivers that she's making today?
She does, Judge, and just, I would like to point out to the court that, on the top part of the statement, it states that this is a third degree felony. However, if you look at the sentence of the indictment, I was alleged by the state that the state jail felony, and confirm that is what they're going forward on. That is what they need to do today, is the state jail felony.
All right, thank you, Mr. Manning. All right, Ms. Wolf, I see here that you've been charged by indictment with a state jail felony offense of possession of a controlled substance in penalty group 1 less than 1 gram.
Yes, sir.
The plea agreement in this case is to proceed, for the state to proceed, the prosecution under 1244A of the law, which indicates to me that if you plead guilty to this offense, the agreement is that you would be convicted today as a felon, but your punishment, which is recommended at 1 day confinement in the county jail, with you receiving credit for 1 day of time already served, in addition to your financial obligations, fine, restitution, court costs, that you would be convicted as a felon today, but punished as a misdemeanor with that plea agreement. And the range of punishment for a state jail felony under section 1244A is maximum confinement in the Van Zandt County Jail for up to 365 days and a fine of not more than $4,000. Do you understand that range of punishment?
Yes, sir.
I see here that the plea agreement would fit within that legal range of punishment, meaning it does not exceed 365 days and the fine does not exceed $4,000. So understanding the plea agreement and the range of punishment, Ms. Wolf, do you still wish to go forward?
Yes, sir.
All right, Ms. Wolf, then I'm going to ask you at this time, how do you plead to possession of a controlled substance in penalty group 1 less than 1 gram?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No.
Or it accepts the defendant's plea of guilt. Mr. Manning, any objection to states 1?
No objection, states 1, Judge.
All right, states 1 is admitted and the court does take judicial notice of Ms. Wolf's judicial confession. Anything further from the state,
There you go.
from the defense?
That everyone defends.
All right, court will review the evidence. All right, court's reviewed the evidence. I do find sufficient evidence to convict Ms. Wolf for this offense. The court will follow the plea agreement in this case. Court hereby convicts Wendy Camille Wolf of possession of controlled substance in penalty group 1 less than 1 gram. Court will assess punishment under section 1244A of the Texas Penal Code at 1 day confinement in the county jail. court will give Ms. Wolf credit for 1 day of time already served. Orders her to pay a $2,000 fine, $180 restitution, $290 court costs, and reimburse Van County $535. Ms. Wolf, are you paying any of your fines or court costs or reimbursement today?
No, Judge, we're gonna be setting up a payment plan and I've directed her to go down to the Pride once she gets done today.
All right, Ms. Wolf, do you understand what happens if you do not follow through on your payment plan? Can you tell me what that is? Okay, you understand that as long as you're making an effort to discharge what you owe, then I won't issue a warrant for your arrest. But the moment you quit paying and you quit communicating, and you quit trying, warrant goes out. And we end up right back where we are today. You understand? Okay. All right, Ms. Wolf, you're hereby remanded to the custody of the Van County Sheriff so we can carry out the terms and conditions of the sentence. I'm gonna have you step forward here to be fingerprinted by the deputy. After that time, then I want you to go down to the end of the hall, set up your payment plan. Yeah, just one. I got to deal with one issue. I'll help you out. Ms. Young. This is CR 22-121. All right, Ms. Young, court sees that you are represented by court-appointed counsel, Mr. Kurt Knoll. And Mr. Knoll is unavailable today due to illness. However, also see that there's been a motion to substitute counsel filed by Mr. Kyle Still. Did you retain Mr. Still? Okay, and is Mr. Still going to make an appearance today?
No, he told me that he was not gonna be able to make it today. He was trying to get it pushed back to August. He said that he sent the motion to substitute to Mr. Knoll a week ago, but Mr. Knoll hasn't signed it, and he has COVID, so I wasn't gonna be able to be here this week.
Right, I'm not as worried about Mr. Knoll. I'm more worried about Mr. Steele. How come he's not here today?
Mr. Knoll didn't sign the motion to substitute.
Okay, so are you asking the court to allow Mr. Steele to become your attorney of record?
Yes, sir.
But I'm saying, why is Mr. Steele here today? If he wants to be your attorney and you want him to be your attorney and you have a setting today, why is he not here today?
I don't know, sir. He said that he talked to the court this morning and that he asked for the court date to be pushed back, that I still needed to be here.
Judge, I spoke to Mr. Steele at the end of the week. He informed me that he was going to be unavailable this morning. I believe he's also emailing coordinator who was out last week. I believe we were both under the impression it was set this afternoon. I think I told Mr. Steele that erroneously. He said he could be available this afternoon. So we may want to give Mr. Steele some leeway, because I do believe I told him, I believe it was set this afternoon. I think I read the docket. So Mr. Steele will likely be available this afternoon, at least based on my communications with him. I don't know his schedule, obviously, but I believe he was under the impression, because I was under the impression it was set. So we may want to reach out to his office and see if he's available. He said he was unavailable in the morning. He's trying to get back to the office for this afternoon.
All right, Ms. Young, so what I'm gonna do is have you come back at 1:30, unless Mr. Steele can zoom in to the hearing today. I'll have you come back at 1:30 and ask that Mr. Steele make an appearance today
Yes, sir.
on your case. He can appear via Zoom. He knows how to do that. So just come back here at 1:30 unless you can get Mr. Steele to log in and get to your hearing this morning.
Okay.
Okay. Thank you, Mr. White.
Yes,
All
sir.
right, Mr. White. This is CR 1110, State versus Christina Ann Cagle Beaver. We're set for arraignment. Ms. Beaver, the court finds that you've requested a court-appointed attorney. The court's reviewed your application. I find that you make too much money to be qualified under the law. So what I can do for you, Ms. Beaver, is if you want to hire an attorney, I can reset the case and give you time to do so. Do you want to do that? Okay. All right, I'm going to reset this until either August 9th or 11th. Do you have a preference?
No, sir, either.
Okay, court will reset Ms. Beaver then for arraignment and status to hire attorney on August 9th. And that will be at 9 a.m. Okay, we're gonna bring you a form here. Well, actually, come on up here. To the deputy, we're gonna have you sign the form. We'll have your reset date on it, and then once you get the yellow copy, you'll be free to go. And Ms. Beaver, once you get this yellow copy, then you're gonna have conditions of pretrial release, which means that the bond that you posted in this case is gonna have conditions on it. That you not drink, not do drugs, not commit new offenses, things of that nature. And Mr. Waddell will have more information about that. Once you sign this, get the yellow copy, then you'll go meet with him. And then once he says you're done, then you're good to go. Yes, go ahead and meet with Mr. Waddell, and then once you discuss with him, then you're free to go. All right. For the record, cause number CR 22-177, State versus Danny Mike Dittman. Court has received confirmation that Mr. Dittman appears to be in the Wood County Jail on a possession of controlled substance less than 1 gram. Appears that it may have been a failure to appear. Looks like bail set at $300,000 in that case. Court's going to find Mr. Dittman's bail in this case to be insufficient. The court's going to raise that based on his incarceration in Wood County. We'll reset this case until August 23rd on a status and arraignment. Do I get that one? There it is. Perfect. Perfect. Patty. Joseph Rushing. All right, Mr. Rushing, this is cause number CR 22-156. Mr. Rushing, you're charged by indictment with what appears to be a third-degree felony. I'll get this one. Deputy, for a second. Charged with what appears to be a third-degree felony offense of possession of a controlled substance. Mr. Rushing, the court finds that you requested a court-appointed attorney. I've reviewed the paperwork, and under the law, you do not meet those requirements. So the court can, what I can do is I can reset your case today for about 30 days to give you time to go hire an attorney to represent you, if that's what you want to do.
Yes, sir, please.
Okay. All right, the court's going to reset you until August 9th. That's going to be at 9 a.m. All right, Mr. Rushing. Deputy Phillips is going to bring you this form. I need you to put your address, sign here, and we'll date right here. This will have your reset date on there. Yeah, let's see here. No, and so Mr. Rushing, I need you to report to pretrial release. They're gonna have conditions for you to sign, so come over here and meet with these officers and they'll give you more information. Once you meet with them, then you'll be free to go. And for the record on Wayne Whitworth, Mr. Whitworth, I indicated earlier, was in the Reunion Plaza Healthcare Hospital. Court's gonna reset him for status on August 23rd. Mr. Shaquille Rogers. All right, this is CR 22-115. Mr. Rogers, I have you set for status on hiring an attorney. Have you sought to hire an attorney to represent you in this matter?
Yes, she gonna be absent. She got 2 courts to do in Sherman and Ennis today, so that's why she's here today.
So have you hired an attorney?
Yeah, her name Miss Barbara,
Barbara?
Barbary, something like that.
You don't know your attorney's name? Is that her first name? Is that her last name? What is it?
Last name.
What's her first name?
Oh, she didn't tell me.
You don't know her. You don't know your attorney's first name. And you're not sure of the last name.
The last name is Barbara.
Can you spell it for me?
BARBREY.
EY? When did you hire this attorney, Mr. Rogers?
3 weeks ago.
And did you pay her?
Not yet, sir.
I'm gonna suspect right now that you didn't hire her because you didn't pay her. I'm looking in your case to see if she's filed a letter of representation. Customarily, attorneys are not going to send in a letter to the court saying they represent someone until they get paid.
Right.
So you're telling me that you haven't paid her?
Yes, sir.
Yeah, there's no letter of representation, Mr. Rogers. So that means right now you don't have an attorney. That's a problem. Because we reset this case so that you could hire an attorney. You didn't hire her. So what am I supposed to do? Just keep resetting your case? What if you never hired an attorney?
When I talked to her, she was like, she wasn't gonna be able to make it. But she had two other courts to do. Then she was like, to see if you can reschedule it.
Well, what I'm saying, Mr. Rogers, is that I don't know any of that to be true. You're asking me to take your word for it because one,
I got a number if you want.
I want her to be here with you.
Right.
It's not my job to go call your attorney to find out, one, if she's your attorney. Right now, she's not your attorney.
Right.
Because you haven't paid her and she hasn't filed a letter of representation. So I've got no business with her. I've got business with you. I reset your case. I told you I'm going to reset your case so you can hire an attorney, and you didn't do it.
Right.
So what am I supposed to do? Put yourself in my shoes. What am I supposed to do? You come up for your case. I gave you time to do something and you didn't do it. What am I supposed to do?
I talked to her.
So says you. But she's supposed to be here with you. That's
right.
The best way to do it is have her stand here next to you.
Right.
Have her file a letter of representation. I mean, I want to believe you, but why should I?
I understand you can't because she's not here, but
so why didn't you hire her? Why didn't you pay her?
I didn't have a chance to. But I got the money, but she just didn't come through because she got 2 other cases to do.
So did you ever think about hiring a different attorney who could be here for your case?
I can.
No, I'm saying, did you not think about that? What did you think was going to happen when you showed up here today without your lawyer?
Either I can reschedule or I don't know. I called 2 of them, but I had one, but she was like, she don't do the cases for control
substances.
stuff. Yeah. And then the other one I called was Miss Barbara, and she was like, she wanted to make it because she got 2 other court in Sherman and Indy.
If you would have paid her, she would have sent in a letter of rep. She could have waived today's hearing and you wouldn't have to be here. She wouldn't have to be here.
Right.
But that's not what we've got. All right, Mr. Rogers, this is what we're gonna do. I'm gonna drug test you today.
All right.
If you're dirty, you're gonna stay with me.
All right.
If you're clean, I'm gonna give you a reset. I'm gonna give you an opportunity to go call her office and then have you report back to me. Okay?
Yes, sir.
So come over here and have a seat. You have Mr. Rogers. Okay. Mr. Smith, are you ready to anyone or you need time?
Good, I'm hoping that Mr. Gerard gets here.
Mr. Shaw, while you're here, let's talk about McClellan, just to put that on the record. So this is CR 22-188 and 189. I'm sorry, Miss McClellan, State versus Julie Darlene McClellan. So it does appear that Miss McClellan was taken into custody by the U.S. Marshals on June 29th. We were set for arraignment today. Is the state intending to proceed on those cases? Do we want to reset? What?
Your Honor, the state would ask to reset before we make an announcement. Obviously, what the Fed do. We believe that we could also prosecute this. I believe it arises out of the same transaction, but I do believe the charges are separate. However, we would most likely defer to the feds in this situation, but with it being picked up last week, we just aren't sure what the status on that is. So we would just ask, essentially, Judge, if we could get the August, I believe 23rd is the date we've been putting out to, just to give us time to kind of all get on the same page and figure out what's moving where. Is that okay with you?
I have no objection.
All right, court will reset, Ms. McClellan then for a status on the federal custody and arraignment on August 23rd. Christian Grindell. This will be a sanctions court hearing. All right, Mr. Grindell, this is a sanctions court hearing in cause number CR 19177. Looks like you were sanctioned 3 days in jail for violating by drinking alcohol. Looks like you complied. You served your 3 days in jail, right? You also paid your $190 to probation. That's good. I show a couple things you didn't comply with, though. You didn't pay $50 to the court collection officer. You didn't do your 20 hours of community service, and you didn't take your life skills class.
I had planned on paying my court fees when I came up here today for court. I had the money to pay it. And I set everything up with my boss to take 2 days out of each week to go and do community service at the Resource Center in Gun Barrel. I haven't started it yet, but I got everything in line to be able to go do it without missing out or getting fired from my job.
What kind of job do you have?
I work in tree service.
Do you work on the weekends?
I work 6 days a week.
6 days a week.
Every day except Sunday.
Okay. All right, so let's talk about what you have to do to make sure that you finish your probation, because that's what we're trying to do, is keep you on track to where you don't fall so far behind. You are behind, but if you fall too far behind, you're going to be in an untenable situation where it's going to be hard for you to complete your probation. All right. You have to pay, I'm sure talked about this with your probation officer, but I'm gonna talk about it again. You have to pay the $190 a month all the way until November of 2024. That's just to make sure that you expire on time with probation. Okay? You have to pay $50 every month. How much do you have today to pay towards your work?
I was gonna pay 100 on my court case.
Okay? And you have to work 20 hours of community service. I show you haven't worked any of your community service. Is that right?
Yes, sir.
So you have 450 hours of community service that you have to get done before you can be off probation.
Yes, sir.
Okay, you're delinquent 300. You got put on probation back in December of 2019. So that's why it's 20 hours. It's usually 10 hours a month.
Yes, sir.
It's having to be doubled now because you didn't do anything from 19 all the way up until this time. So now you're way behind on that.
Yes, sir.
That's why you have to take 2 days off each week just to make sure that you don't get violated for your community service. And you're deferred on a second degree burglary by habitation. That's 2 to 20. All right. You get a motion to adjudicate. That's minimum 2 years to a maximum 20. You're a young guy, right?
Yes, sir.
How old are you?
22.
22. So this is the option I'm going to give you. Okay. I need you to pay $190 again next month to your probation officer for your fees. Okay. I need you to pay, I want you to pay the $100 today to the court collection officer. You're going to have to pay $50 a month to the court collection officer. You're going to have to do the 20 hours of community service. You're going to have to take your life skills class. You're also delinquent in your restitution. So I want you to pay the $190 to probation, the $50 to court collections, $50 on your restitution, 20 hours of community service, and you have to take that life skills class. All right, so I'm not going to require you to have completed the life skills class before the next court date, but I want you to at least enroll in it so that I know you're in it. Okay, so that's 5 things. That's 5 things you have to do: probation fees, court fees, restitution, community service, and you have to enroll in that life skills class.
Yes,
That's 5 things.
I'm supposed to report tomorrow to my probation officer and get the life skills thing set up.
Okay. Okay, good. All right, so here's the thing, Christian. I need those 5 things done. For everything that you don't do, 1 day in jail. For every one of those that you don't do. That means if you pay $50 to probation, that's not $190. That'd be a day in jail. If you don't pay the $50 to your court collection officer, day in jail. If you don't do your community service, 20 hours. You do 15 hours, day in jail. That's not 20, because 15 a month is not going to get you on track. 20 is. Okay. And you got to pay that $50 to your restitution, and you've got to enroll, make sure that you're enrolled in that class. So if you meet with your probation officer tomorrow, you get enrolled, then you'll take that one off. But for every one that you don't do, it's going to be a day in jail. That would be the sanction that I would impose on you today. You can tell me you accept that, or you can tell me, no, you don't accept that.
I accept it.
Okay. All right. So for everything that you don't do is going to be a day in jail. You're already having to work 6 days a week, do all the community service, take classes. That's going to make things even more difficult for you. Okay. We're not trying to make it more difficult, but we're trying to get your attention so that you can stay out of prison. Understand? All right. Come over here and meet with the probation officers, and we'll have some paperwork for you. Okay. Well, I think let's, we're gonna reset your case. I'm gonna give you until August 23rd. So I'm gonna give you August 23rd to be all those things done. Okay, so you need to have that done before August 23rd. Giovanni Chavez Rosales. This is also a sanctions court hearing. All right, Mr. Chavez. You had some sanction in court, things that you had to do. Let's see. To complete your cognitive behavior course. It shows that you've registered for that, right?
Yeah, I got the orientation, the 28, I think. I gotta talk to my probation officer.
It says July 11th.
Oh, Joe, okay.
Yeah, make sure you know that date. Otherwise, you're gonna
I'll
miss
write
it.
down.
Shows that you paid your probation fees, shows that you did not pay your court fees, and you did not do your community service. Tell me why you didn't do those things.
Oh, I have a community service with me, but on court fee, I did pay the wrong court, and I did talk to this Daniel Griffin, I think. That's her name.
So what court did you pay?
I paid I'm not sure, I paid the other one, but she told me which correct one to pay now. Well, I accidentally paid for 2 months. I paid for the wrong one. But she did call me like on the, I think it was like 2 weeks, like before, maybe.
What about your probation hours? What do you say?
Oh,
You did probation hours, but did you turn them into your probation officer?
I haven't turned it in yet.
Why not?
I'm not sure why they're not putting it in the system. Well, I haven't right.
Right, but I'm saying you did your hours, but you didn't turn it in your probation officer.
Oh, which is this probation officer?
Well, what probation department do you report to?
Well, the last time I was here on the 20s, I'm not sure, but the last time I was here, I reported to her, and I did send a picture to her on Friday, I think. No, yeah, on Friday I sent an email to her because she told me to send her an email for the probation hours.
So how many hours did you do?
I did 10 overall this month.
You did 10. You know, you've got a long way to go on your probation hours.
Yeah, I'm gonna get my driver's test is on this Friday. And as soon as I do that, I'm gonna start heading to probation to these hours every mostly day. As much as I can.
All right. So, Mr. Chavez, you understand that we're just trying to keep you on track. The further behind you fall, the less likely it is that you're going to complete your probation. You understand that? And you're on a deferred community supervision for a 3rd-degree felony evading arrest with a vehicle. That's 2 to 10 years in prison. 2 to 10.
But since I've been doing everything good now, as soon as I get this driver's license taken care of, I'm gonna start hitting probation every day. Well, all my hours every day.
I'm just saying, you understand what you're facing. If you don't do what you've been court ordered to do, if you don't do it, you understand what's going to happen to you in your future. Do you understand?
2 to 10 years.
2 to 10 years in prison. How old are you?
21.
21. 21, and you're already having to worry about going to prison. So we're trying to get your attention here. We're not trying to make it hard, not trying to be mean or ugly. Trying to get your attention that these things are very important. Community service is very important. I tell people all the time that it's easier to go to jail and sit in a jail cell and be told when to eat, when to use the bathroom, when to sleep, and when to go outside. That's much easier than being on probation and being responsible to make sure that you're working, that you're paying your fees, that you're doing your community service, that you're being a productive citizen, that you're staying clean, you're staying sober, that you're following all the laws. That's much harder. So your opportunity here is either you're going to remain on probation and be in the community, be at home with your mother, your family, or you're going to be locked up and told when to come out, when to go in, when to use the bathroom, when to talk, when to shut up. You don't want that, do you?
No, sir.
We don't want that. They don't want that. And the only way for you to get the probation department out of your life, and me out of your life, is to do what you're supposed to do. And that's what we're trying to get your attention on.
Yes, sir.
Okay, so these are things, I'm gonna reset you until August 23rd. And these are the things that you have to get done. Okay?
Yes, sir.
You have to pay $60 towards your probation fees. Gotta make that payment. You gotta pay $260 to collections. Okay, that's your court costs. Okay?
Yes, sir.
And you're delinquent 31 and a half hours. I'm gonna reset you to August 23rd. That's more than 30 days. I want all of those 30 hours done.
Oh, you want me to do more than 30 hours?
I want you to do 31 and a half hours before you come back on August 23rd.
August 23rd. Okay.
And I'm gonna give you a form that's gonna have that reset date. I want all those done so that you're caught up on probation hours, your community service hours. All right, I want that. I want you to stay caught up on that. And if you have 10 right there, then that's great. You're gonna do 30 more, and then we'll get you, if we can get you ahead, that's even better.
Yes, sir.
So you're just gonna have to make this happen. If you don't do those three things for everything that you don't do, if you don't pay your fees to probation, you don't pay your fees to the court, and you don't do your community service, for everyone you don't do is gonna be a day in jail. That would be the sanction. If you accept that, do you want to accept that sanction?
Yes, sir.
You want to accept that agreement?
Yes, sir.
You don't have to. And if you don't, probation office may file a motion to revoke or a motion to adjudicate. I don't know. But these are the things that I'm offering you. But there's going to have to be a penalty if you don't do it. I'm not just going to sit here and say, okay, we'll just reset you. If you don't do 10 hours, you don't do 20 hours, we'll just keep on resetting you. Doesn't work that way.
I'll make sure I get caught up.
Okay. All right. So I'm gonna have you come back on August 23rd, and I hope that when you stand up there, if this report I get says that you complied with each one of those, it'll be a 2-minute hearing, done, reset. Give you commendation for doing a good job, and we'll reset you a little further out, give you an opportunity to get back on track. And once you get back on track, quit coming to court.
Yes, sir.
Okay? All right, come over here and meet with the officer. I'll have you sign with Deputy Phillips here. I'll have your reset date. Mr. Crane, are you ready with Mr. Padron?
Yes, we're just gonna pass the case, set for Your Honor.
Come on up, let's make it enough. This is CR 21-336. State of Texas versus Carlos David Padron. We're set for docket call. Okay, what's your announcement, Mr. Crane?
I'm sorry.
What's your announcement?
We're not gonna take it to trial. We'll set it for a plea.
Okay, so you've received discovery, reviewed that, you're,
I'm in the process of getting it. Yes. I've communicated with the prosecutor's office. It is a multi-step process doing this. I have the last step to do, but I've spoken to my client and I've told him that I'll review all the evidence and chances are we'll take it for a plea. I'm sure the prosecutors, at least historically, have been very reasonable to work with, so I don't think it's going to be a problem.
State, is there an offer in this case?
Yes, there is, Your Honor. I believe it is for deferred probation.
And what's the length of deferred? Can you just go ahead and spell out the exact recommendation?
Sure, let me pull it out. State's offer is for deferred with a $2,000 fine.
All right, so Mr. Crane, I see that today's the court indicated was the final docket call, so you're wanting to set this for a plea?
Yes, sir.
All right, would your client be willing to waive his right to a jury trial today and set it for a plea?
Yes.
Ms. Heisel, can you print out a waiver of jury trial?
Yes, Your
Get that to Mr. Crane. All right, so Mr. Crane, she's going to print out this form. I want you to go over it with your client, and then once you're done, y'all let me know and I'll call you back up and we'll conclude the case.
Yes, sir.
Okay.
Thank you.
All right, Mr. Rogers. Go back to the podium. Or actually, just come right over here. Do we have a form for him? I can't. Yeah. All right, Mr. Rogers, this is CR 22-115. All right, what I'm gonna do, Mr. Rogers, is I'm gonna reset you for one more time. All right, to hire an attorney. I'm gonna reset you to August 9th. Court also notes that you passed your drug test. All right. So what I expect, I thought I was clear last time. Let me make sure I'm clear this time. On August 9th, I expect to have your attorney's information filed into the case by the attorney. And I expect them to be here with you. If you hire an attorney, they can file a waiver of arraignment and we can reset the case to another day. But you got to pay the attorney. They have to file a letter of representation with the court so I can acknowledge who is responsible for your case. All right. So I'm gonna have you fill out the notice of appearance. We'll have your reset date of August 9th on there. And so you can communicate that to your attorney. You need to go and pay your attorney. All right, that's the way attorneys are hired. They're not going to just show up and say, oh yeah, I'm willing to take this case, but in hopes of being paid. Right. And if this attorney can't do it, if this attorney's too busy, or they say, hey, I can't be there at this time, then go get another attorney.
Okay. Yes, sir. Appreciate it.
How you feeling? Yes. All right, Mr. John. All right, we're back on the record, CR 21-336. All right, Mr. Padron, I'm gonna ask you to raise your right hand. I'm gonna swear you in. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right. Mr. Padron, you portray now. All right, Mr. Padron, so I hold in my hand a document that's entitled Waiver of Jury Trial. Have you discussed this with your attorney, Mr. Crane? Do you understand that if the court approves this form, what I'm approving is the fact that you understand that you have a right to a jury trial in your case? That means you have the right to have the court summons a jury that you would then be able to come in here, go through jury selection, pick 12 and panel them as your jury, have the case tried by the state, have the opportunity to cross-examine all of the state's witnesses, to confront all of their evidence in front of that jury, and for that jury to decide whether you are guilty or not guilty in your case. Do you understand that? Do you understand that even you have that absolute right? No one can take that away from you because it's guaranteed to you by the Constitution. You understand that? You also understand, though, that you can waive the right to that attorney. You can tell me that you've considered the facts of your case, the circumstances of your case, that you discussed it with your lawyer, and you do not want to have your right to a trial by jury, and that you want to waive that and then enter into a plea agreement with the state to resolve your case, or you can have your case tried to the bench, to the court, where the court would make all of those same decisions that the jury would. Do you understand that? Understanding all of those things, are you intentionally, knowingly, and voluntarily waiving your right to a jury trial in this case? All right, and Mr. Crane, you're joining in with your client in requesting the waiver of jury trial.
Yes, sir.
State, Ms. Heisel, you're waiving the state's right to a jury trial.
Yeah, sure.
All right, the court will find that Mr. Padron has been admonished on the record as to his right to a jury trial in this case, and that he has waived the same intentionally, knowingly, and voluntarily. Court will approve the waiver of jury trial and set this for a plea. And we will set this. Are you available on August 9th or 11th, Mr. Crane?
The 11th, probably.
Afternoon is ideal, but I think we have to have morning please here.
Well, we have morning pleas for those that are not in custody. My afternoon is for,
He'll stay out.
they'll stay out.
Yes, August 11th would be great.
Okay, are you sure that you're available that day?
I believe so, yes. And if not, I'm not, I'll have whatever is currently scheduled removed.
Okay, do you want to, if you want to check your schedule? then
I
that's
have it at home, but I have a pretty good memory.
Okay, all right, court will set Mr. Padron then enters plea on August 11th, and that will be at 9 a.m.
9:30 or 9?
9 a.m.
9 a.m. Very good.
All right, Mr.
We'll see you then, Judge.
And let's see, I need a notice of appearance. Did you fill out a notice of appearance form, Mr. Crane? Sure. Fill that out and then put the reset date on there of August 11th at 9 a.m. to enter plea, have him sign it, and then give him the yellow copy, and the white copy will stay with the court.
Yes, sir.
All right, after you get that yellow copy, Mr. Padron, you're free to go. Mr. White, are you ready? Are you?
Mr. Waddell,
Mr. Waddell, if you'll approach. Mr. White, Mr. Woodwhite. has conducted a urinalysis exam of Mr. Atkins. It's my understanding, Mr. Atkins, that you have tested positive for multiple substances, including marijuana, cocaine, and methamphetamine. All of those would constitute a violation of your pretrial release conditions in this case. Court therefore is going to find your personal bond to be insufficient at this time. Or it's going to take you into custody, set new bail in this case for those violations. Okay. So I'm gonna have you step over here with Deputy Phillips. That's all. Okay, and so for your information, and for Mr. Atkins, his personal bond was in the amount of $30,000. Court will double that today to $60,000. Cash will surely. Okay. Saw it. Mr. Manning, are you ready?
Yes, Judge. Amber.
Newman.
Atkins.
This is Ms. Williams.
Yes, and then if we want to speak on this first.
All right, let me see. We'll wait on that. Ms. Williams. State Farm versus CR 2252. State of Texas versus Crystal, entry and net Williams. This Williams, right, on the place of road. And you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth?
Yes, sir.
All right, make sure you let me finish, okay? My court reporter has to take it down. All right, Ms. Williams, a few questions for you. Are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any kind of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Docket. Are you pleased with this representation?
Yes, sir.
Like you've had enough time to discuss your case with them, have all of your legal questions answered?
Yes, sir.
Think about this paperwork that you've read and signed today that you do not understand.
No, sir.
Mr. Manning, you believe your client to be competent?
She is, Judge.
Have you explained to her her legal rights?
I have.
Believe that she understands those and the waivers of those that she's making today.
She does.
Ms. Williams, I see that you are charged by indictment with a state jail felony offense of theft of property less than $2,500 of value, with 2 or more previous convictions. A state jail felony, Texas carries a range of punishment not less than 6 months or more than 2 years confinement. For Texas Department of Criminal Justice, and also includes an optional fine not to exceed $10,000. You understand that range of punishment
Yes, sir.
means that any plea agreement or sentence handed down by the court or jury would have to fit within that minimum and maximum. I see here that you have a plea agreement in your case wherein you would plead guilty to that crime in exchange for the state's recommendation that your sentence be put within that minimum and maximum at 18 months of time in the state jail, with you being, with that being suspended today, you being placed on community supervision or probation. In addition, you would have a fine, court cost, and reimbursement fees. Is that your understanding?
Yes, sir.
So if you understand the plea agreement and you understand the range of punishment, you still wish to go forward with your plea in this case?
Yes, sir.
Meaning, did I state the plea agreement correctly?
You did, Judge.
All right, so Ms. Williams, I'm gonna ask you at this time, how do you plead to theft of property less than $2,500 with 2 or more previous convictions?
Guilty.
Are you pleading guilty to that crime, Ms. Williams, because you are guilty of committing that crime but for no other reason?
Yes, sir.
Has anyone threatened, force, or pressure you to plead guilty today?
No, sir.
Court will accept the defendant's plea of guilt. Training and objection to the state's evidence.
No objection.
It's evidence submitted and the court takes judicial notice of the defendant's judicial. Further to the state.
No, Your Honor, we rest of
For the defense.
Nothing from defense, Judge.
Court will review the evidence. Right, court review the evidence. I do find enough evidence to convict Ms. Williams of this offense. Court will follow the plea agreement. Court hereby convicts Crystal Internet Williams of theft of property less than $2,500 with 2 or more previous convictions, a state jail felony. Court assesses her sentence at 18 months confinement in the state jail division of TDC. Court suspends that sentence, places her on 3 years community supervision. Orders her to pay a $1,000 fine, $290 court cost, $535 reimbursement. Ms. Williams, you've read your probation conditions in this case, have you not?
Yes, sir.
You understand what's required of you. I'm assuming that you've been on probation before.
Yes, sir.
Did you successfully complete those probations or did you?
I'm currently on probation.
Probation. Have you ever completed a probation?
I have.
And have you ever unsuccessfully?
No, sir.
You understand what's required of you?
Yes, sir.
You understand what happens if you violate any of your probation conditions, which means you don't do your community service, you don't pay, you put a new crime, any violation of any of these conditions, you understand what happens.
Yes, sir, I do.
I mean, in your own words, what you believe will happen.
I'll get provoked and I will have to serve the sentence that is required of me.
That sentence is what?
Well, 18 months. Yes, sir.
So your sentence has been set today.
Yes, sir.
That's the sentence that you'll get if you violate. Our hope is that you don't violate.
Oh, no, sir.
I don't think you were in the courtroom earlier. I was telling another young man, my opinion of probation versus jail with prison. Were you in here?
No, sir, I was not.
So I really do believe this. It's a lot easier to go to jail or prison, sit in a cell and be told when to eat, when to use the bathroom, when to go outside, when to talk, when not to talk. It's a lot easier. It's almost like being a child being told what to do. Someone else decides for you when those things happen. That's much easier than it is to be an adult, who's responsible and accountable, that has to go to probation, do their community service, pay their fees, stay out of trouble. It's much more difficult to do that. So I don't see probation as being a slap on the wrist. I see it having a lot of requirements that only people who are motivated to do that are able to complete. I hope that's you.
Yes, sir.
If it's not you, then I'll make it very easy for you to go to jail. Prison. Understand?
Yes, sir.
So don't violate. Go over there and do what you're supposed to do. No excuses. Do your community service, pay your fee, do what you're supposed to do. Probation officer tells you to jump, just find out how high. Understand?
Yes, sir.
Right? Ms. Williams, you're hereby remanded to the custody of the Manzane County Community Supervision and Corrections Department, so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with Deputy Phillips. After that, we'll step over here with these officers and they'll give you more information about probation. Jennifer Gonzalez, CR 2166. All right, Mr. Meeting, Ms. Gonzalez is set for pretrial.
Yes, Judge. I've spoken to my client and we've begun developing some of her defenses, but we need to view the DVDs. We've not received those DVDs. My understanding was they were copied about a year ago when the case was begun by a previous DA's office employee, but I have not received those at this time. So I request additional pretrial to get those DVDs so I can review those with my client.
No objection, Your Honor. I saw that they were copied about a year ago. Don't know what happened with copies. We'll make new copies. We have no objection.
All right, court will reset Ms. Gonzalez for pretrial on August 11th. That'll be at 9 a.m. Ms. Gonzalez, why were you late this morning?
My ride, they were delayed.
All right, once you sign and get the yellow copy, you're free to go.
Thank you.
All right, the court has called Starry Sky Robinson, Mitchell Gilbert, Stephanie Rios, Robert Gerard, Robert Schultz. Court has had their name called in the court at 9 a.m. They were not present as previously ordered. Court has also had their name called loudly distinctly in the courthouse with no response. Court's going to issue judgment nisi for all those individuals. However, the court will take the nisi under advisement until Friday at noon for Mr. Robert Schultz to allow Mr. White or Mr. Nicholas to provide the court with medical documentation as to why Mr. Schultz could not be present in court today. That's under advisement until Friday at noon of this week. For all others, the judgment nisi will issue. The court's going to stand in recess until 1:30.